Hello, everybody. Nice to see you all in person. Good to see you. So I'm Chandra Andrade. I am a partner in the employment practice, obviously. And we're here to talk about investigation-related topics. I'll let Jaya introduce herself as well.
Hi, everyone. I'm Jaya Bajaj. I'm a senior associate in the employment practice, and we're excited to talk today about effective investigations.
So, one of the reasons we decided to speak to this topic discreetly today was I am on the heels of a jury trial in San Bernardino where lack of investigative effort was a real sort of driver of the entire trial. So we're going to be talking about sort of lessons learned during the course of that trial, as well as in other litigation and in summary judgment, other contexts as well. So you can kind of get a sense of how ineffective investigations can come back to bite you later. So to kind of frame the discussion today, the first thing we'll talk about is just the legal duty to prevent harassment. It also applies to discrimination and retaliation under the Fair Employment and Housing Act. And so, basically the FEHA requires employers to take all reasonable steps necessary to prevent discrimination, harassment, and retaliation in the workplace. So listed here are four sort of key pillars for how you can comply with this requirement. One of them is having an anti-harassment policy and then training employees on that policy. As I think most of you are aware by now, you do have to have regular anti-harassment training for your supervisors and now non-supervisors as well. And then the two other ways that we'll talk about today is responding to and documenting complaints and then taking remedial action where you have found that discrimination, harassment, or retaliation have occurred. So, to kind of hone in on that last point, conducting investigations and having a very solid record of your investigation and sort of what you end up doing with those findings is a really key component of this requirement to take all reasonable steps to prevent harassment, discrimination, and retaliation. So I'm going to give a little bit of an overview of that trial that I just came back from to kind of distill down how important this is. So the plaintiff in the case was a former employee of my client who worked at one of their warehouses in San Bernardino for about 4 years. And this individual came forward with claims of harassment against one of his coworkers about 4 years in, so right at the very end of his employment. Through the course of discovery, we found out that this individual had a number of mental health concerns, including autism, extreme paranoia, delusional disorder, and schizophrenia. And so over the course of our investigation during the lawsuit, we came to conclude that his claims of harassment were really his perception, and that there wasn't actual harassment occurring against him, and he had misperceived sort of normal workplace interactions. But when he went to human resources, his 4th year of employment, did you have a question there, sir? Okay, just a hand up. Unfortunately, the human resources team did nothing. So there was an individual who happened to be sitting at the HR desk and intook his complaint pretty briefly. She allowed him to write out a statement that was taken and sort of left on the desk, and nobody did anything about it. About 3 months later, another HR person who was sort of transitioned on to this investigation that wasn't an investigation did a brief check-in with the plaintiff, and in her telling, the plaintiff said, things are okay. The alleged harasser is being nice to me now. I don't really want him to get in trouble. I'm okay. So the HR person took that and did nothing further. There was no interview of a single of the harasser. There was no interview of the harasser and none of the other witnesses either that the individual had written down within the body of the statement that he had submitted. So we tried the case to a jury, and what was sort of an interesting, very mixed jury verdict was essentially they found no liability for the harassment. So, our theory that there wasn't actual harassment in the workplace was borne out by the jury's verdict. But the jury ended up finding my client liable for tort claims of intentional and negligent infliction of emotional distress And in interviewing the jurors after the fact, they all said the reason for their verdict was HR's inaction and doing nothing when he came forward with a complaint. So, and the verdict was about $1 million, including some punitive damages. So, I think the reason I wanted to highlight this and sort of frame our discussion today was it's a case study in how important the effort to respond to a harassment complaint is. The inaction alone created this 7-figure liability against my client, and the jurors were really displeased to see that the level of sort of lack of concern and, as they called it, recklessness when the individual did come forward. I just wanted to point out on this slide that legally, there's a difference between the FEHA cause of action that may be triggered by a failure to act on an investigation. So under the FEHA, there's a cause of action called failure to prevent harassment. And legally, this came up at the trial a few times, you can't have a failure to prevent harassment under the FEHA unless the individual is able to establish the underlying harassment. The courts recognize you can't fail to prevent something that never happened. Under the tort claims, however, under intentional and negligent infliction of emotional distress, you don't have to have the underlying harassment actually established in order for that liability to potentially attach, as we found out the hard way in the jury trial. So we'll refer back a little bit to this case and sort of other elements of it as we speak today, but I'll hand it over to Jaya to talk about recognizing and intaking the harassment complaints.
Sure. So as perfectly illustrated by the example Chandra just shared, managers and human resources have the responsibility to address situations that arise that could be viewed as sexually harassing or creating a hostile work environment as soon as they become aware of those complaints. And that could be because someone comes to you with a complaint, or it could be because you observe improper conduct. But as soon as management or HR are made aware, there is a duty to begin to address that complaint. Before moving along, I'll note that that duty to address extends to non-employees in the same way that extends to employees. So the complaint can be about someone that the employee is working with, or it could be about someone who was a vendor or a third party. In fact, we had a lawsuit a few years ago in which an employee alleged that they had been harassed by a third party while at a vendor site. And that person was not employed by our client or even the vendor that the employee was stationed at. But our client still made the decision to remove the employee from that situation as soon as they became aware of that. And that was viewed very favorably by the court. We even obtained a dismissal on summary judgment. So it just really speaks to the fact that this duty extends to all situations and not just employment specific, employee-employer specific situations. So here we have a couple of formal avenues for reporting complaints. I'm not going to read through the whole slide because I know we're short on time. The most classic situation is that an employee comes forward either to their supervisor or human resources, either verbally or in writing with a complaint, but it can come about in various other ways. Human resources or managers might themselves observe improper conduct in the workplace. But as soon as these concerns are observed or raised, that duty to investigate and address begins. So here we have just a couple of examples of some complaints that should trigger a red flag, a call for investigation or action. I'll somewhat quickly read those out loud. So the first one we have here, Sarah complains that her supervisor Robert is always giving her negative performance feedback in team meetings in front of other people. She feels that the work environment has become, quote, toxic and, quote, hostile. So those toxic and hostile words are kind of key phrases that should be raising some flags that perhaps this is a situation that requires investigation. Second example, Jonathan complains that after he returned from a recent leave of absence, Rachel told him that he, quote, looked tired and commented that he missed a lot of work. So this, again, is a comment which could be viewed as making someone uncomfortable, particularly after they've just returned from a leave of absence. It could be viewed as discriminating or harassing that employee. So this should be raising some red flags that perhaps there is an investigation that needs to be done. Lastly, kind of more obviously, Evan tells his supervisor, quote, I don't want you to do anything, but I felt very uncomfortable when ... And kind of going back to Chandra's example, where she had a situation where an employee had said, I don't want you to do anything, things are okay. That wasn't good enough. It was still, as we know, the court still found that, or the jury still found that there should have been an investigation. So just because an employee says all's good, I don't want you to investigate it, if there is a red flag or a signal that this is a potentially harassing or hostile work environment situation, the company still has a duty to look into it. So as I just touched on, employees may have, many reasons why they bring complaints forward. And it's important to always extend a listening ear during that initial complaint conversation. It can be a very sensitive conversation. Employees often feel nervous bringing these concerns to HR. So it's important to listen, ensure that the complaining employee feels respect, feels that their complaint is being taken seriously. We'd also advise avoid expressing your own personal opinions about what might be going on. Just listen, ensure them that that the complaint is going to be taken seriously. It's worth noting here, and kind of dovetails back to the presentation we just heard. It's important to assure employees that they will not be retaliated against for bringing these complaints forward. Often employees fear that they are going to embarrass the person who they've brought a complaint about or be disciplined by that person. So it's important to remind employees, your complaint is being taken seriously and you're not going to be retaliated against for raising this to our attention.
So we'll turn next to kind of the basics in terms of conducting the actual investigation after you've done the intake. So, we've listed out maybe some more obvious steps here in terms of interviewing the complaining party and the subject, other relevant witnesses that are identified. Typically once and in the course of interviewing people, you identify documents and other records that may be worth pursuing. That can include video footage as well, so not just physical documents. Once you've collected your witness statements, interviewed people, collected other documentation, this may lead you to other avenues that you'll want to also chase down. Some witnesses may raise their own concerns, which typically would then require opening another investigation for that, keeping them separate. But eventually you're going to compile everything and reach some findings and try to tie your findings to the evidence and the witness statements that you collected. Very key is documenting everything in a well-written report. Of course, we're here if there's particularly sensitive questions or avenues that you're not really sure about. We're happy to consult. You can consult with internal counsel as well. And then once you've determined your response, you have to, of course, communicate the outcome to the involved parties. So, just to touch on a couple of these steps in a little more detail, when it comes to interviews, you don't have to feel wedded to a particular sequence. It's pretty typical to interview the complainant first, just to kind of scope out the actual claims and what you're actually going to be looking at. But sometimes that's not possible. Some people may, maybe as a result of their concerns, immediately go out on a leave of absence or make themselves unavailable. So you have to be flexible to perhaps interview other people in a different sequence. There's different schools of thought in terms of when and how early you interview the subject. And oftentimes the decision can vary depending on the circumstances. But for example, if you're doubtful that the subject is going to be very forthcoming, then you might want to collect other evidence and get other people's input before you interview the subject. So you sort of have some ammunition to tie them down with during the course of the interview. You don't want to limit yourself to a single interview. Keep that in mind. Oftentimes you learn new stuff and then you have to circle back. So don't feel hesitant to do that. The law and the regulations do require that investigations be prompt, but it also requires that they be thorough. So you kind of have to balance that out. You don't need to, in every single investigation, turn over every single stone, but you want to make sure that you're getting the information you need. And again, sometimes that may require doubling back to people, waiting for documents, that sort of thing. I think we'll turn to kind of some other specifics when it comes to interviews, but Jay, we can maybe go through these ones a little bit quickly since we're low on time.
Sure. At the outset of an interview, it's important to establish a courteous and professional demeanor with the witnesses. You can provide some brief background, begin to establish rapport with them, help put the witness at ease. You should explain the process, clearly identify who you as the investigator represent. You don't want to make any mistakes of thinking that have the witness think that there's an attorney-client relationship if you, for example, are an attorney or the company doing an investigation. You don't want to promise confidentiality. Things that the witness shares with you could be shared with others on a need-to-know basis. You should be requesting that the witness cooperates fully with the investigation, and then also uses their judgment when discussing the existence of this investigation with others. Ask for truth and candor, and make that same reminder about not retaliating against, that they will not be retaliated against for anything that they share. There's a lot on this slide, but the basics of what to ask, you're starting with try to get the who, what, when, where, and why. I like to think of it as the funneling approach. You can start broad with some basic questions, who was present, what was said. And once you start to get a basic lay of the land, hone in on some more specific questions. You don't need to limit yourself to those broad questions. You can start to ask some more tailored specific questions. But oftentimes when you're starting out, it's helpful to just get those big, broad questions out.
So, some tips similarly for what to avoid when you're conducting interviews. You obviously don't want to come in being very accusatory of people. To Jaya's point, maybe using more open-ended questions instead of, did you harass so-and-so at the holiday party? You want to try to, I won't go through all of these, but I think the one at the end is I think important, especially starting out conducting interviews. We have a natural human tendency to want to, make friends and make the person feel at ease, but try to avoid expressing agreement or disagreement with the individual's version of the facts, or certainly predicting what the outcome might look like for the individual until you've gathered everything that you need to in order to make those final findings. We wanted to kind of walk through a couple of common things that come up when we're advising on investigations, if it's helpful. So, you might have an employee, whether the complainant or just a witness, who's refusing to participate. You can require people to participate in investigations, and oftentimes we want to see that in a harassment policy, that it says, you're required to participate if you're named as a witness, or certainly if you're a subject or complainant. If somebody's really hesitant and they don't want to participate, which is common, people are hesitant to call out actions by their colleagues, you should document your efforts to get them into the interview, right? And try to make it clear through documentation, hey, we tried you on this date, you didn't respond. Because if you end up deciding to take some sort of progressive disciplinary action for their non-participation, having that nice record is very helpful. A lot of times we get a request from employees to try to record the interview, and that's something that we often recommend against. The recording itself can take on a life of its own, get into the wrong hands. And the recording itself can have a chilling effect, we find, in terms of what people are willing to share. What if someone wants to bring a buddy to the interview? Also something we don't recommend because of the sensitivities around these things, and having private information in the workplace being shared with someone who doesn't work there. And kind of relatedly, if the employee wants to bring an attorney to the interview, this is something to discuss with your legal counsel. Sometimes it may make sense to just allow them to have their attorney in the room, particularly for really sensitive investigations, or if the person's particularly nervous. But there are ways to allow that kind of make it fair for the employer as well, right? The employer too can have a lawyer in the room, so that the investigator, who's oftentimes not an attorney, has that sort of backup, instead of just going toe to toe with the other person's attorney. So definitely some complexities here that you can discuss with your legal counsel, but just kind of our initial recommendations if you get any of these requests.
So in many investigations, investigators have to make credibility determinations, especially when there are two conflicting statements. Oftentimes there needs to be some assessment of which witness might be more credible than the other. There are, of course, some objective pieces of evidence that investigators can rely on, such as emails or other documentation that might contradict what a certain witness has said. But investigators should also consider biases, predispositions, their own observations about the witnesses. Do they seem extra nervous? Are they making conflicting statements? Are they being evasive? So certain factors, variables like that can help when making these credibility determinations, which are rather common in an investigation.
And the credibility determination should be stated expressly in your report, right? If you found that somebody wasn't credible, even what they're saying is one thing, but you find that statement to probably be false, you should note that, this person came in and they were evasive. And so making all those credibility determinations express in your report can go to this next idea as well.
The he said, she said outcome. So oftentimes you can't really make a credibility determination, and it truly becomes a he said, she said outcome, where perhaps you aren't able to substantiate a certain complaint because there just either isn't enough evidence or the allegations can't be proven or disproven. In those situations, it's important to still consider potential action. If workers are not separated, for example, after a potential harassment complaint has been raised, and there's a second report or ongoing or repeat allegation, the employer could still be found liable for having failed to prevent that harassment, even though they conducted the initial investigation. I actually have a case headed to mediation where that is the exact fact pattern. So it's some steps to consider are ongoing monitoring, changes to the reporting structure, maybe workplace trainings. So even if you have this he said, she said outcome, there are still some potential steps that you may want to consult with your counsel about taking. So as Chandra touched on a little bit ago, investigation reports are one of the most critical components of the investigation. It shows that the company took the allegations seriously, implemented analysis, and it is one of, or if not the most useful tool in defending claims regarding harassment or failure to prevent. A report should primarily focus on the factual findings. The investigators should report the facts and not try to draw legal conclusions. In other words, the investigators should avoid making conclusory statements like employee X engaged in sexual harassment against employee Y. Rather, they should state the facts and avoid those conclusions. So, for example, assume a situation where employee X touched female employee Y in a sexual way. There might be two ways to describe this in an investigation report. The first could be employee X sexually harassed employee Y by touching her inappropriately. The second could be just noting that on X date, employee X touched employee Y in a way that other coworkers found to be of a sexual nature. So there's a subtle but key difference in how those two statements are written. One is the investigator making a legal conclusion that sexual harassment has occurred, and the other is a more clear and direct recitation of the facts.
And to that point, the common conclusion that's being tied to something in the investigation report is a policy violation, right? The investigator is deciding whether a policy, for example, the sexual harassment policy, has been violated and not whether the law has been violated, right? That's a key difference.
And one last thing I'll note on investigation reports, often when you are working with counsel on investigation report, you might exchange a couple drafts back and forth. And we would caution/advise that even in those initial drafts, refrain from making those legal conclusions, because even those initial drafts could at some point be discoverable. So I'd say that when you're drafting the report, just stick to the facts and try not to make those legal conclusions.
Right. So the investigation report is not the only document that's generated in an investigation, right? There's all kinds of stuff. There's the notes that interviewers should take, and I recommend taking notes of interviews and storing those. There's emails, correspondence, witness statements, et cetera. A lot of employers are going towards a more centralized record-keeping system for their investigations, which I definitely recommend. If you have a clear repository where notes and all these other parts of the record can be stored, it not only creates more organization, and it becomes easier for people to find stuff when inevitably a lawsuit arises years and years after the fact. But in my experience at trial, it's much easier to authenticate a record when you don't have the witness that created the record anymore, which again happens kind of a lot. If you're able to show to the court with the current employee, well, we have the central repository, it's used the same way every time, this is where everything gets stored, then that witness has a better chance of being able to authenticate a record that somebody else generated years ago simply by virtue of having this nicely organized business record. So something to think about in terms of how to use this stuff later on and how a centralized system can be really helpful. I think the bigger question that we want to emphasize is what not to do with documentation, right? We've had a lot of cases which are really driven by unfortunate documentation. Oftentimes that's not the actual investigation report. So I don't know if you can see this clearly on your screen here in the room, but this is an image of the actual investigation report that was generated in the case that went to trial for me last year, where my client had the nice central repository and, good first step, but the person that actually ended up sort of taking the investigation, following up with the individual and then doing nothing, was similarly sloppy when it came to using the kind of record keeping system to kind of close out the report. So here, this particular record keeping system had drop down menus. And one of them, for example, finding confirmed, she just clicked on confirm to kind of close out this record keeping system. And obviously this was front and center at the trial in terms of, well, see, they confirmed that there was actual harassment, right? And of course, the person that did this hadn't done anything to investigate, so confirm nothing. But we had this unfortunate record there that's really hard to get out of. So if you do have a record keeping system, obviously use it well and use it correctly. One of the things that we see really tank our cases the most are things that are said in the most informal ways, right? So your Slacks, your Chime messages, your informal messaging systems can often create the worst evidence. And that's because people have their guards down, of course, right? People are more willing to say things or express off the cuff opinions in these informal chat systems, not thinking that they're part of the record. But as a lot of you in the room probably appreciate, when it comes to trial and discovery, those things are going to come out. So, this is the second image here on the screen is a real life example of a case I have on my desk now, where the investigator sends this email to the supervisor of someone who had just come forward complaining of harassment, in particular that her coworker had sent a nude picture of himself to her. And so the investigator goes to their chat system and actually writes this. I guess if she feels really triggered by the pic, she should file a police report. Again, it's really out of our hands. I can get some guidance from the investigations team on this, but ultimately, if it didn't happen at work, we can do nothing, can't do anything about it. Also, I'm not saying anyone is innocent or guilty, but I know it always takes two to tango. If the complainant wants to go down that route, she can, but she will be questioned as to why the alleged harasser felt comfortable to send this anyways. So, what I really hate about this message is that sure enough, there was an investigation done and they ended up terminating the person for sending the picture. So the company did the right thing, no harm, no foul, except for this unfortunate Chime message that was sent before the investigator had done anything either, right? So it just shows this bias and this real sort of nonchalance and real dismissiveness towards the complainant that is going to be a real problem for my client if the case goes beyond the mediation, where I really hope it settles, because this is going to be ugly at trial. So, one other thing that we wanted to touch on, it's not on the screen, but, attorney-client privilege communications, they can really be your friend, because if you have communication with counsel, then of course the argument is you can protect that against discovery. So if you are in the middle of a really difficult investigation, there's sensitivities, then feel free to lean on your in-house or external legal counsel to send those, difficult questions and opinions first, and make sure to label those attorney-client privilege and confidential, and make clear that you're seeking legal advice. That can be a really important tool to be able to talk through some challenging issues and not have it be produced in discovery. But, we've also seen unfortunate situations where legal will send guidance and then the person receiving that forwards it around the company, right? They forward it to someone else to execute, or they send it to someone else for another reason. And so that can break the privilege. So if you're working with investigators who maybe don't tend to work with legal counsel that often, make sure you're advising them on sort of how to use attorney-client privilege communications and how not to breach that.
So once an investigation has been completed, one of the final steps, not quite final yet, is determining the response. So if allegations are substantiated, the investigator or human resources or management will want to work together to determine appropriate disciplinary measures. As an initial point, the person making that decision should always consider how others who've engaged in similar conduct in the past have been treated to avoid a discrimination claim based on the potential disciplinary measure. The best practice in this regard is usually to work closely with legal and HR when making these decisions. Typically, they are the groups who have information regarding how these complaints have been handled in the past and would best be able to advise how it should be handled now. Two similar cases could be treated differently. It really is a case-by-case situation. For example, in this situation, an employee might have supervisory authority over the complaining party, where perhaps in a prior situation, it was two coworkers. That could result in a slightly different outcome. So it really is a case-by-case determination, and best practice is to work with legal and HR when coming up with a response. If allegations are not substantiated, sometimes there still is some appropriate disciplinary measure or some action that could be warranted. As a clear point, the employee, even if a complaint is not substantiated, should still be made to feel comfortable in raising future allegations and making future complaints. They should not be penalized for raising the complaint, unless, of course, there was some finding during the course of investigation that the complaining party acted in bad faith. But assuming it's a simple matter of, like the example we talked about before, he said, she said situation, the complaining party should not be made to feel uncomfortable or not taken seriously for having raised the complaint. And there may be still some measures that the company could implement to make the employee comfortable going forward. So once a decision is made and an outcome is reached, the company should promptly communicate the outcome both to the complaining party and to the alleged harasser. The communication in almost all cases should not be very detailed. So we have an example up on the screen here, which I will let you all read in your own time, but it essentially thanks the employee for having raised the concerns, informs them that they conducted an investigation, and kind of states a very high-level overview of what they are deciding to do based on that investigation, and lets them know if they have future concerns, they should report it to HR immediately. Thanks them again for bringing it to HR's attention. So very high level, but lets the complainant know that the investigation has been completed. Similarly, an outcome must also be communicated to the subject of the complaint. So if allegations are substantiated, the investigator or whoever is delivering the outcome should provide a brief explanation. Again, this does not have to be and likely should not be super detailed, but should provide a brief explanation of the findings and the discipline that is going to be imposed. If the allegations are not substantiated, that should also be communicated in a matter-of-fact way. Try not to express personal opinions, and should include a reminder again about that anti-retaliation concept.
And as Jaya points out, being pretty high level is typically our recommendation for communicating the outcome. And we don't offer to provide a copy of the investigation report, for example. And some employers have real hesitance about providing copies of their reports. But keep in mind, under the labor code, employees are entitled to request copies of their personnel file. And one of the categories of records that typically needs to be included is records of any grievances concerning the employee. So if the person came forward with a complaint, usually that's going to be considered a grievance, and the resulting report may need to be produced. So something you might discuss with counsel, but There's a little tension between most employers' resistance to providing and offering copies of the investigative record and this requirement to provide personnel records. So we'll close with that. You know, we've talked a little bit about retaliation already today, but obviously make sure to communicate to everybody involved about the anti-retaliation policy, that their participation in the investigation is not going to result in any sort of retaliation.